సుమన్ పెన్ ఎక్కడ పెన్ ఎక్కడ అంటారు పెన్ ఇదన్నా కలర్ స్టార్ట్. Okay, so today Bharat sir is not available. I am taking the current affairs classes. Okay, shall we start? Okay. The first article which was appeared in the Hyderabad edition about Prahar initiative, the counter-terrorism policy taken by the Minister of Home Affairs. So, okay. I have picked only 3 articles which are very important, so I don't want to bother you by picking other articles. So, okay, the first is Prahar, the initiative, the counter-terrorism policy taken by the Ministry of Home Affairs. So, the objectives of this policy is to criminalize all terrorist acts. Means the terrorist acts whichever will be taken place in the country or taken place in the country will be criminalized through this particular policy. But we have particular act, separate act for that. We will discuss that also. Okay. The first is that criminalize all terrorist acts, and second is halt the terrorist activities. I mean, prevent the terrorist activities. You know, this is very important because, you know, after terrorist activities happened, means the impact has happened, so we can, you know, have a rehabilitation, all those things, but the first priority should be preventing terrorist activities or unlawful activities in the country. So this policy, the Prahar called, is not trying to prevent those terrorist activities in the country. This is the second very important objective of this particular Prahar initiatives, which was released by the Ministry of Home Affairs. Ministry of Home Affairs is obviously entitled with responsibility of law and order or internal security and in the country, right? So internal security is the responsibility of Ministry of Home Affairs in the country, and the very important, you know, strengthen coordinated among the different agencies in the country. We have, you know, National Investigation Agency, you know, different agencies we have. RAW we have, you know, intelligence agencies. We don't have that much of coordination in the country because there is a overlap in the functions, overlap in the responsibilities. So this Prahar initiatives try to eliminate those overlap functions and ensures coordination between the agencies. So because of this reason, when there is a coordination and cooperation between different agencies, there will be a easier activities to tackle the terrorist activities or unlawful activities in the country. This is, and what are this policy have a 7-pillar approach. Means there are 7 pillars in this particular Prahar. So through that 7 pillars, this Ministry of Home Affairs is going to curtail the terrorist activities and also punish the terrorist individuals and organizations within the country. What are those 7 pillars? The first is prevention, as we already mentioned. One of the objectives of the Prahar initiative is prevention, and also this is one of the pillars of the particular Prahar initiative. Okay, the prevention, how we can prevent the terrorist activities. First, ensure there is an infrastructure in the country. and there is police force, other military forces, operational army, and also we have the cyber infrastructure. The main intention to initiate this program or this policy to enhance the cyber resilience in the country, because during the initiation of this policy, Ministry of Home Affairs said that nowadays counter terrorism not only in the physical form but should be also in the digital form, cyber activities, right? Those state actors and non-state actors. State actors include governments, right? Non-state actors, private organizations. These state organizations also funds non-state actors. So these non-state actors and state actors will coordinate and cooperation to wage cyber terrorism in the country. So by enhancing the infrastructure, cyber capability in the country, so we can prevent and also provide better resilience in the cyber terrorism activities. And again is responses. This comes second tier. When the terrorist activities already happened, then you are providing quick responses to the victims and also those who are affected within the country and also out of the country. We will discuss why out of the country is very important. We will discuss when we are discussing the law, anti-terrorism law in the country. Okay? And aggregating internal capacities. What is the aggregating international capacity? We have already capacities in the country, within the country to counter the terrorism, but these capacities or capabilities are not enough now. So as we already highlighted, the terrorist activity, domain of the terrorist activities are increasing from physical form to cyberism. Next, the AI. So the digital form, AI is another mode of terrorism, right? So we have to enhance those capabilities, modernize police forces, modernize the agencies, and also modernize the capability to prevent the terrorist activities, and also the responses after the terrorist activities taken place. Those responses should be very modernized so that quick responses will be provided within a short period of time. So this is and human rights and rule of law. And there are two categories of people in the terrorist activities. One is those people who are waging, conducting terrorist activities, and other set of people who are victims of terrorist activities, right? So by revamping the legal criminal justice system or legal reforms, taking certain legal reforms, we are providing the opportunity to both the set of people to put forth their grievances within the judiciary. So both the people, even certain people, let's say for example certain organizations, certain people who are not involved in the terrorist activities are being punished, but those people can provide evidences. So those people can be provided enough natural justice. We have the natural principles of natural justice. Means that we should be hearing both the sides of the story. Without hearing the both sides of the story, we should not punish someone. That is the idea of reforming the criminal justice system within the country, within the domain of terrorist activities. And again is that attenuating enabling conditions. It means we have that certain conditions within the country, so we should make them capable to prevent the terrorist activities. And also the sixth one is aligning the international efforts. We have financial task force. There are multiple organizations, IMF, World Bank, and also we have Shanghai Cooperation Organization. Within that we have a permanent body called terrorist rats. So this organization is a permanent organization within the SCO. So we have to strengthen such cooperation in the international domain, international relationships, so we can fight the terrorist activities not only in the country and also outside the country with a cooperation with all the countries. And also recovery and resilience. And after the terrorist activities have taken place, we have to provide compensation to the victims and also rehabilitate them properly, so that we can recover and also build infrastructure, so we can show that we have a resilience against such activities, terrorist activities or unlawful activities within the country. So this is with respect to 7 pillars of Prahar. But we can say that, so why now we are put forth in the idea of Prahar? We don't have any law, we can ask, but there is a law which is called Unlawful Activities Prevention Act of 1967. This was law which enacted in 1967. So this law amended so many times, but I will tax some of the amendments which are very important for your examination perspective, and also why UEPA is very important, because when 1967, when this act was enacted, the only activities which were covered under this particular law was unlawful activities. And again in 2004, the terrorist activities are also included in this particular law. Why? There was one law called Prevention of Terrorist Activities Act. This act was declared unconstitutional and removed. So after removing the particular law, there was some law which can prevent terrorist activities and also punish the individuals and organizations who are taking place terrorist activities within the country. So in 2004, the terrorist activities were included in this particular law, Unlawful Prevention Act of 1967. You can ask me, what is the difference between unlawful activities and terrorist activities? Anyone can tell me? What is the difference between unlawful activities and terrorist activities? You can try, just if you are not sure about it, you can just try. Okay. Unlawful activities, those activities which will question the integrity of the nation, will question the sovereignty of the nation, and also which activities will lead to cessation of any part of the country. Cessation of any part of the country and will be disintegration within the country. These activities are called unlawful activities. But what are the terrorist activities? Both the activities are defined under Unlawful Activities Prevention Act of 1967. Nowhere else in our any statute would define terrorist activities except in Unlawful Activities Prevention Act of 1967. Under this, terrorist activities include those activities which are also same categories, which threaten the sovereignty of India or integrity of India, but using terror as a means. Terror as a means. Unlawful activities which can use the activities, for example, say saying something, writing something, using media, you can post something because you think that you have a freedom of speech under Article 19, right? But you have certain restriction under Article 19, right? Under Article 19 clause 2, you have certain restrictions, right? So under these restrictions, this particular act was enacted in 1967 to curtail the unlawful activities which are non-violence in nature. These activities non-violent in nature, means there is no bloodshed, using guns, all those things. But terrorist activities which will include the violence activities which create terror among the people by using guns, RDX, bomb blasts, all these things covered under terrorist activities. And this particular law says that the terrorist activities are not only taken place in the within the country but also outside the country. Because of that reason, it's become very important to have a cooperation in the international relationship to combat terrorism. And also in 2008, we amended the particular way of law and included that it's allowed 2008 amendment allowed the central government to freeze, seize or attach funds, any other properties with which are with these properties are which belong to any terrorist organizations. Right. So this amendment gave the central government the power to designate any authority as a terrorist authority. And again in 2013, again this particular law was amended and included money laundering and also terrorist financing. Terrorist financing, sorry, that is spelling mistake, I think. Terrorist financing. Money laundering and terrorist financing were also included in this particular act in 2013. Again in 2019, this particular act was amended. This is the most controversial amendment with respect to Unlawful Activities Prevention Act of 1967, which included cyber terrorism, terrorist financing and also seizure of property and designation of individuals as a terrorists. Why it is important? Because earlier we can't designate any individual as a terrorist. We were only capable to designate an organization as a terrorist organization or unlawful organization under the particular, because this act provides two activities. One is unlawful activities and terrorist activities, right? So now earlier only we were capable to designate an organization as unlawful organization or terrorist organizations, but under 2019 amendment we are now, the central government allowed to designate any individual as a terrorist. You got it? So the 2019 this is very time taking process if I discuss 2019 amendments in detail, but it's not necessary. But from this particular policy, and you should be knowing that there is a law called Unlawful Activities Prevention Act of 1967, which covers both unlawful activities and terrorist activities, and there is difference between unlawful activities and terrorist activities. Okay, got it? If you have any doubts, I will clear. Otherwise, I will move into the next article. Okay, okay, done. And next is WhatsApp and WhatsApp case. This was happened in 2021. Competition Commission of India, which is a statutory body, if I am not wrong. So this Competition Commission of India imposed fine. Imposed fine on WhatsApp. Why it imposed a fine on WhatsApp? One is take it or leave it policy and user consent and also data sharing with the Meta. These are the three issues. One by one I will explain. The first is that take it or leave it policy. What is take it or leave it? Whenever you open any app, there will be terms and conditions, right? If you click those term conditions, then only you are allowed to use that particular app, right? So you just you should allow, or you can just you can't use that particular app. This is also applies in case of WhatsApp also. So Competition Commission of India says that this policy making citizens mandatorily give consent to the terms and conditions of the WhatsApp, so then only they can use the WhatsApp. This is against the concept of a dominant position, because there is a concept called dominant position in the economic. By using this position, you can raise the prices of any goods and services within the country. You can stop any other entity making same, providing same goods and services in the country, and this dominant position should not be abused within the country. This should be taken care within the country so that there will be competition in the market. Other entities, other entrepreneurs will come in the market and provide goods and services in the cheaper costs. Though because of that, citizens will be happy by receiving goods and services within a very few rupees. That is the concept. But Competition Commission of India alleged that WhatsApp is abusing the domination position because in the Indian market, except WhatsApp, there is no other instant messaging app to compete WhatsApp. Recently, there was one app, I think Aratai. So Aratai is made sound, but it is not, that much capable to provide competition to the WhatsApp. So Competition Commission of India is saying that the dominant position, which enjoyed by the WhatsApp, is being abused, so that WhatsApp playing very major role and also monetizing the data which is received under the WhatsApp. So Competition Commission of India is saying that whatever the data received after the consent is now being sent to the Meta. Meta is the original organization. It's an umbrella organization. Within that, WhatsApp is one of the organizations and one of the applications. And so Meta is receiving data from the WhatsApp. So this is violation of the particular law, Competition Commission of India Act of 2002, I think, right? So this is violation of the particular act, section 4 of the Competition Commission of India Act. But WhatsApp, however, challenged this particular fine of 213.14 crore in the National Company Law Appellate Tribunal. But after that, challenging this particular decision, National Company Law Appellate Tribunal upheld the fine imposed by the Competition Commission of India and WhatsApp. This is the shorter story. But now WhatsApp, what is WhatsApp doing? WhatsApp is appealing this particular fine in the Supreme Court. This is the okay. Now 3-judge bench is hearing the case now, and WhatsApp is saying that it is not quite right. So to say that WhatsApp shares its data with the Meta, and also because we have Digital Personal Data Protection Act of 2023, which will taken care of these data sharing methods. Competition Commission of India is not entitled to talk about the data protection or privacy issues, which is not the right authority. Which is the right authority? Digital Personal Data Protection Act will take care of all those things. We are complying the Digital Personal Data Protection Act of 2023, and it says that there is no violation of any particular law with respect to sharing any data with the Meta. This is the idea put forth by the Meta. WhatsApp and Meta both. But the question arises that there is demarcation between right to privacy and dominant position. Right to privacy. So right to privacy is a fundamental right under Article 21, right, which was declared in the Potosami judgment in 2017. I think of already knows that, right? And then abuse of dominant position is a Competition Act of 2002. So abuse of dominant position is the violation of Competition Act of 2002, and violation of right to privacy is a fundamental right. Right. So if WhatsApp is saying we are violating the privacy which is taken care of under the Digital Digital Data Protection Act, right? But Competition Commission of India is saying that we are not talking about the data privacy here. We are talking about the violation of dominant position, abuse of the dominant position. You are violating the Competition Act of 2002, not the fundamental right under Article 21. Okay, you got it right? If you have any doubts, I will clear, and also will, otherwise I will move into the next article. Okay. Yeah. Do you have any doubts? Okay. Okay. Election Commission, selective intensive revision. I will covering all those issues with respect to, which is appeared, I think, I don't know the page number. The selective intensive revision is taking place in many states. First happened in Bihar, which led to exclusion of 65 lakh voters, and also it is now being taken place in West Bengal, which challenged in the Supreme Court. Supreme Court said some procedural irregularities are there, so you should address those procedural irregularities. After addressing the procedural irregularities, you can conduct any selective intensive revision in any state. But minorities are condemning this particular activity and are saying that there is a selective community or selective people are being excluded under the name of selective intensive revision. So now because of this revision, because of this particular issues, the one thing came into light, that is independence of Election Commission of India. So the Election Commission of India enjoys independence in terms of services conditions, and also the process of removal of Chief Election Commissioner and also other electional commissioners. So now we will discuss all those things, which whatever the things mentioned in this particular article, we will discuss all those things. The first is that allegations which are discussed, and the opposition parties, India bloc. These India bloc opposition now trying to move a motion in the parliament so that they can remove the Chief Election Commissioner, because they are alleging that this particular Chief Election Commissioner is not that much of independent, and he is is in favor of the ruling party, and the ruling party is using Election Commission of India in their favor. That is, two terms are in the name. One is politicization of bureaucracy, and also politicization of constitution, because the Election Commission of India is a constitutional authority. When you are interfering in the affairs of the constitutional authority, you are politicizing the constitution. That is very two important terminology you can use in your mains also, so that will help you to get more marks. And also free and fair elections. The concept of free and fair elections is mentioned in I think one of the cases, Minerva Mill case, I think, I don't know if I'm not, I'm sorry, Minerva Mill's case. In this particular case, Supreme Court said that free and fair elections is one of the basic structures, basic structure doctrine, which laid in the Keshwanand Bharati case in 1973. So free and fair election is one of the basic structures of the constitution, so you should not violate the free and fair elections. Now the free and fair election is not being conducted. According to the opposition, the elections are in the country are politicized, because the ruling party is using Election Commission of India in their favor, and the free and fair elections are not being conducted in the country. Okay, that is the issue, and independence of the Election Commission of India, and also constitutional safeguards under Article 324 and 326. We will discuss all those things in this particular article. Okay, let's start. So Article 326 talks about the adult franchise, voting right to vote. Okay, na? Right to vote is a Right to vote. Right to vote is a legal right or constitutional right?
Legal.
No, it is a constitutional right. Okay, na? Right to vote is a constitutional right which is mentioned in the Article 326. Okay, and then Article 324 empowers the Election Commission of India, or Chief Election Commissioner in this particular case, superintendence, direction and to control the elections to the President, Vice President, Parliament and also State Legislature. These are the powers entrusted with respect to Chief Election Commissioner and other election commissioners. Okay, Election Commission of India is multi-member body. It became multi-member body in 1993. Yeah, 1993. So earlier it was in 1989. It became multi-member body, and again in 1990s. It became single member body, and permanently in 1993 it became multi-member body. We will discuss that again. Okay, na? But now we will discuss Article 326 and 324. Okay, na? 324. We discussed Article 326, right to vote, constitutional right, and now appointment controversy. This is the independence. Why independence is being compromised now? Because oppositions claimed that the composition of the selection committee to the Chief Election Commission of India is dominated by the executive. For example, Prime Minister is being from the ruling party, and other minister, Union Minister, ruling party, right? And leader of the opposition. In these three members body, even if there is a majority of 2:1, there will be, the decision will be prevailing against the majority of one person, right? So both the ministers is from ruling party. There will always be ruling parties. The decision will be in favor of ruling party. Because of that reason, there is no independence, and also the appointed is politicized. But in in the earlier case, Supreme Court gave a judgment. The composition of the selection committee should be Prime Minister, leader of opposition, and Chief Justice of India. But central government enacted this particular act, appointment, Chief Election Commissioner and Other Election Commissioner Appointment Act of 2023, and they replaced this particular composition with this. And now this particular act is being challenged in the Supreme Court, because in Anup Barwal case, Supreme Court said that the composition should be Chief Justice of India, Prime Minister and leader of opposition, and now there is no place for Chief Justice of India in this. Right, though now this particular act is challenged in the Supreme Court, and the hearing will be in the March in 2026. This is with respect to appointment controversy. Okay, now with respect to removal of the Chief Election Commissioner and other election commissioners. Okay, removal of the constitutional safeguards. These constitutional safeguards ensures independence of Election Commission of India. Why? Why the removal process, if more rigid, why it ensures independence of any body, any constitutional body for that matter? Authority? Okay, next. If constitutional safeguards in terms of removal are being provided to any constitutional authority, let's say for example Supreme Court judge, CAG, and also Chief Election Commissioner, why these constitutional safeguards ensures independence of any authority? Yeah, that's right. So that is very important. These particular constitutional safeguards ensure independence of any particular constitutional body. And with respect to this, Chief Electioner can be removed only in the manner of Supreme Court judge. right? How Supreme Court judge can be removed? Right? So this particular procedure is mentioned in the 2 minutes. This particular procedure is mentioned in Judges Enquiry Act. Judges Enquiry Act of 1967, right? So in this procedure, there will be a motion. If this motion passed in the Lok Sabha, 100 members should be signed it, and if in case of Rajya Sabha, 50 members of the parliamentarians should be signed. After this motion signed by the members, it should be submitted to the speaker or chairman in the respective houses. And if this particular motion, if admitted by the speaker or the chairman, there will be a committee, investigative committee, consisting of CJ or Supreme Court judge, Chief Justice of High Court, and distinguished jurist. If this committee found that any particular judge is guilty, then there will be a special majority. The majority of the members and the 2/3 members present and voting. Right? Not all the members. Not all the members. That is absolute majority. Absolute majority is different. Special majority is different. Special majority is majority of the members, total house, and 2/3 majority of the present and voting. Okay, na? So this is special majority, and absolute majority is different. Okay, na? That is. And this, if the majority is passed with special majority, and any particular judge, removed from, is considered removed from the office. This is the procedure being followed, and also this particular procedure should be followed with respect to removal of the Chief Justice of India. And other election commissioners, okay, na? Other election commissioners shall be removed on the advice of the chief election commissioners, right? So other election commissioners, but in Vineet Narayan case, Supreme Court said that Chief Election Commissioner should not take suo decision with respect to removal of the other election commissioners. This is the whole idea behind. I wanted to tell it in detail, but time is up. Okay. If you have any dates, I will address, and otherwise I will wind up this session. Okay. Thank you.